last year. Of course, we're probably running late getting started. You know how that goes. And here we are at the Business Summit with Mark, myself, and Tom, um, and at the lovely green bar that we're all missing. So as part of our time travel, I wanted to ask Jill if she would bring us up to speed on what happened with, I think there was one last case there at the Supreme Court having to do with the impeachment process. Jill, you want to take it from there?
Yep, I will. This is a case, and again, as Anna mentioned, it really is the last of the impeachment cases, or the impeachment saga, as we sometimes refer to it. And as many of you know, there was some issues with the payment of senior status judges who serve as per diem judges to fill in for cases. It actually began, we've had a statute in the books in West Virginia really for decades, since I think 1991, that allows payment of senior status judges a per diem rate, and they're not to exceed the payment that is permitted for circuit court judges. There's also, since 2017, an administrative order that permits the Chief Justice to pay a senior status judge more than that in extreme circumstances. In 2019, and actually in 2018, the panel that was impaneled on the Supreme Court, temporary justices, to hear the Workman v. Carmichael decision, the impeachment case, actually determined that the statute was unconstitutional on the basis that it violated our separation of powers principles. So in 2019, the legislature decided to address the issue. It passed a bill to address the maximum payment that would be permitted to be paid on the per diem rate for senior status judges. Now, what's interesting is in that law, in that statute that the legislature adopted, it required, think of this, the legislature required the treasurer to file an action essentially seeking a declaration by the Supreme Court that would prohibit the auditor from affecting payment by the treasurer of these payments by the Supreme Court Chief Justice to affect the payment that would be in excess of the per diem rate should there be an extreme circumstances that would require an excess payment in these situations. So this was interesting because this was contained in the legislation. So, but yet there wasn't at the time that the Treasurer Perdue was required to file this case with the Supreme Court, justiciable controversy. There wasn't an issue or a dispute pending. It was just required by the statute. So really Justice Walker and Justice Jenkins picked up on it too during the hearing, during the argument before the court. Justice Walker, just fresh out of the box, said, "Counsel, where is the case in controversy here? It appears that you're asking essentially for an advisory opinion." And counsel for the state treasurer said, "Well, we're required to bring this action by the statute." So the court said, because the treasurer seeks an advisory opinion from the court, we deny the writ. Now, this is interesting because I think that the legislative drafters were essentially trying to create an action so that the court would essentially affirm this prohibition that there would not be permitted payments above the per diem rates. And I think there was some expectation that given we have two justices, Chief Justice Armstead and Justice Jenkins with legislative backgrounds, there was an expectation that because we have relatively what many view a conservative court now, that they would uphold this legislative view. And in fact, I think what the takeaway is for this case is that the court did what we in the chamber have long asked courts to do, is maintain judicial independence and uphold the principles of reliability that we want courts to do. We expect courts to say, hey, you know, the law is that we only determine those disputes before us. And in this particular situation, there is no dispute before us. And we as a court do not issue advisory opinions. And that's essentially the takeaway from this case.
Tom, would you cover for us where we stand on judicial hellhole watch lists and that sort of?
I'd be glad to, Anna, and good morning to everybody out there in COVID land. Whether you're at home or at your offices, it's nice to be with you. Although I would rather be talking to you all in person at the Greenbrier. So just keep our fingers crossed for next year. We've talked. I think this is our 4th or 5th year trying to cover where West Virginia stands in the Judicial Hellhole Report. And as a reminder, it's published by the American Tort Reform Association, and it's based on surveys of their members, and they have folks that read cases and do other things. So I always like to preface this with just the comment that this is a document that we need to know about. I just would not put it in the category of a scientific survey. You can see that West Virginia, which for many years was a top 10, top 5 judicial hellhole, is no longer considered a bad jurisdiction. And part of that is due to a kind of a continuing trend where they see a balance in our court as opposed to a court that swings from side to side. You can go move the slide. They put us on a watch list this year, and one reason is the same reason they had us on a watch list last year, is a continued criticism that we haven't established an intermediate appellate court. The other reason that they put us on a watch list is because 3 out of 5 of our seats on our 5-person court were up for election. And if you go back to the concept that we're looking for balanced courts and predictability, shifting 3 out of 5 seats gives you a little heartburn. This report was issued pre-election. And so, as we know, Justices Armstead and Hutchison were reelected, and Justice Wooten will take the bench January 1st on Justice Workman's decision to retire, or rather not to run. And so when I think they might have a different view of this next year, because I don't see, we maintain 2 justices. If Justice Wooten is considered left of center, which remains to be seen, then maybe he fills Justice Workman's spot. The other things that they brought up is failure to pass legislation allowing the admissibility of a plaintiff's failure to wear a seatbelt. This is kind of a long-term criticism, as well as a failure of a legislative response to medical monitoring. So we're not top 10. They're keeping an eye on us. And so one of the things I do want to comment on is we're all aware of the opioid litigation, and that is it's multi-district litigation. It's all 50 states, and the federal court litigation is all centered with a federal judge in Cleveland. Multi-district litigation gets sent to one judge to manage it, and then it gets kicked back out to the states for trial. And so some of the West Virginia cases have been kicked back and were set for trial, I think, this month, and now have been moved to January. If you can go to the next slide, Jill. And I just want to point this out. The American Tort Reform Association has been very critical of attorney generals retaining private counsel and bringing lawsuits, and pressing the limits of nuisance and other legal theories to recover in cases like opioids, lead paint, climate change. There's suits over vaping. And this is an area where the ATRA is extremely critical. And this put Oklahoma into the top 10. They had a big verdict out there in a state court case, and their attorney general has been involved in bringing opioid action. So if you move ahead to West Virginia, we know that there is a mass litigation panel case pending in state court in West Virginia, and that's where Mark Williams is otherwise involved this morning. And we also will have a federal trial in the spring. And so what I want to give you a warning of is that very well could give the ATRA heartburn about West Virginia as we move into next year. Now, whether that's valid or not, since this litigation is literally pending in all 50 states, the federal courts, and I mean, even Indian tribes are bringing these suits. So this is a massive piece of litigation. Reported in the press that it may very well be moving towards some kind of settlement. But anyway, I just want to give you a heads up on that. But in terms of the public perception of West Virginia, to the extent it is influenced by ATRA, we're not in the top 10. And so that's a good thing for us, given the strengths and weaknesses of these reports.
Jill, you want to cover stats for us?
Yeah, I sure will. Thanks. So we typically during CourtWatch review what the courts have done and how many opinions they have been issuing. So this is pretty interesting, and I want to sort of just toggle between them. So most of you know that the court issues both signed opinions and memorandum decisions. And signed opinions mean that they conference, and then one justice will actually issue a signed opinion, and there might be a majority opinion, or a dissent may accompany a majority opinion. These are signed opinions. Memorandum decisions generally are developed with, I'll say, a little more haste. Generally, there's consensus. They don't typically have new syllabus points of law. And they're really importantly not necessarily binding on other issues. Now, we as lawyers nevertheless cite memorandum decisions, but we generally look to more frequently signed opinions as sort of the rules of law in West Virginia, and they carry more weight. Signed opinions, nevertheless, we see here, I mean, this is a busy court. Now, what do we all see here? We see fall 2008 sort of sticks out. What was going on in fall 2018? Now, you know, if we were at the Greenbrier, we'd be asking for feedback right now. So the Zoom setup isn't particularly conducive to this. But what we will say, fall 2018, that's when the impeachment proceedings were going on. So in fall 2018, what we can really probably surmise with some comfort level is that the court probably was a little more reluctant to issue decisions because they were under a microscope. So we know that in fall 2018, they really didn't issue very many signed opinions. Spring 2019, you know, there was an election in spring 2019. It really didn't affect the work of the court. And actually, I'll point out, spring 2020, you know, COVID hit in March, and nevertheless, the court was really, really busy. I think Tom is going to touch a little bit on the timeline of COVID and its effect on the courts and orders and so forth in just a little bit. But then the memorandum decisions, they were still sort of churning out decisions along this time frame. The signed opinions really didn't, you know, was a little more affected by impeachment proceedings and so forth in the fall of 18. But look at the memorandum decisions in spring of 2020 during our COVID time. I mean, the court, again, is really issuing a lot of decisions. So credit to it. All right, Tom, COVID.
Sure. I just, if you go to the next slide, just a real quick review of a timeline that we created. You know, like all businesses, like all governmental entities, the court had to deal with COVID. I think that the Supreme Court of Appeals of West Virginia under Chief Justice Armstead was aggressive and really took some care with the measures that they employed. They issued their first order And as of March 12th, they issued a planning document, and this covered everything from how to clean the courtroom through employee issues and other things. And their first administrative order really kind of stopped non-essential things. And they stopped trials, they stopped in-person hearings. And if you had a time limit in between March 16th, and I think it ended up being May 18th, ultimately, if you had a statute of limitation or something due during that time, those deadlines were wiped. And so the court took a pause, I think, to let it get a hold of COVID. The other significant order is, if you see, there's an April 24th order, temporary order on civil litigation. The court issued, and it was only in effect for 2 or 3 weeks, but looking ahead and not knowing where COVID was going, the court issued an order that modified some of the rules of civil procedure to make clear that cases could proceed using remote technology. And there was just some tweaks that were done to that order. And I can tell you, I was on a committee that worked on that order with Mark Williams and others. And certainly we made a proposal to the court, and the court issued an order that had its own changes and things on it, but it was very forward looking. And I thought it was, when you look around the country, very unique order in West Virginia. And so, I think our court took a lead on that. The judicial emergency expired May 15th. We were allowed to resume jury trials on June 29th, grand juries on June 15th. Courts now are managing their dockets in their counties. If they get to a certain level on the state map, they'll close their courthouse. We've had precautionary closures when people have positives, but other than that, the courts are proceeding. And I can tell you, as a practicing lawyer, there's courts that have held live jury trials with shields and masks and all that. A lot of the judges are using now Microsoft Teams to hold hearings and other things. So I really, I think this is a credit to our court that we worked our way through a crisis, and really, except for a short period of time where we stopped doing things live, didn't shut everything down. So kudos to the court on that.
I assume, Tom, too, that if we end up with another shutdown as things have become more and more difficult with COVID, do you think that'll be a blueprint for what the court would do in the future?
That's a great question, Anna. I think the court really does have the tools it needs to move forward in the waxing and waning of COVID, as we all pray for a vaccine. And in fact, you'll see on October 6th, the court still looked at it, entered another set of protocols that made some changes in things to try to do it better. So if we would come to a circumstance where in a county or statewide we had more of a shutdown, I think the April 24th order is a great blueprint, and a lot of the other good work that the court's done to try to just deal with this crisis, but recognize that criminal cases, and they pay, by the way, special attention, abuse and neglect, criminal cases, other things that you just can't close the doors to. Like a civil case, if it gets pushed, it's not, the end of the world, but I really do think they have the tools to handle, whatever's coming. And we're all hopeful that whatever's coming is not going to, it's going to be better than worse.
I will just say, don't let Tom Herney get hold of a picture of you. It's embarrassing. You might end up seeing it in a presentation. And that was me at the Green Bar, apparently having a good time. Okay, I'm going to discuss the right to work law, which is finally the law in West Virginia. The bill became effective, as you can see, this is our timeline, in July of 2016. Kanawha County Circuit Judge Bailey, and I always mention her name because as the case unfolded, the Supreme Court made it very clear in a preliminary decision what she needed to do when they dissolved one of her injunctions in 2018. And she sat on the case for almost 9-10 months before she finally issues a permanent injunction holding that the law is unconstitutional even though the Supreme Court made it clear that it was not. So of course it went back up to the Supreme Court, and the court had it in the fall of 2019, and they issued their decision just before the election. And Jenkins wrote the opinion on behalf of the court. He issued it April 21. And in that, I think it's significant that they did this just before the Supreme Court election that was held in May. I also want to thank the chamber for being an amicus in that matter, and the good work that was done by so many of the people that joined in as amici in this. So the court ruled that the right to work law passed by the legislature did not violate any right of association under the West Virginia Constitution. It did not result in an unlawful taking under the Constitution, and it didn't infringe on any liberty interest that employees had. So right now, and from this point forward, no employee can be required to pay dues, fees, initiation fees, or any sort of fees to a union and as a condition of getting a job or as a condition of keeping a job. And I thought it was interesting too that in the opinion, in the dissent, it was really not quite a dissent, but a concurring opinions of Workman and Hutchinson. And remember, Hutchinson was running for Supreme Court at the time when the opinion was issued in April. But both of them said it's not unconstitutional. We may not like it. We may think the legislature shouldn't have done this, but it is definitely not unconstitutional. I'm going to cover a couple of other discrimination cases. We've had employment law doctrine in West Virginia, but for those practitioners who do labor and employment work, sometimes over the years, it has felt like we did not have employment at will. And I'm sure a lot of employers wondered if we had it too. In the Newton versus Morgantown Machinery and Hydraulics case, another Jenkins opinion, Newton and his coworker got into a fight, and it was a fight started by the coworker, and the employer fired both of the men who had been fighting. Newton claimed that his discharge violated a substantial policy under Harless, and the lower court granted a motion to dismiss the claim. And you might remember the case of Feliciano versus 7-Eleven, where the employee there had engaged in self-defense, but at the time, the employee in the 7-Eleven case had established that they had a genuine fear and that they were in lethal imminent danger. In this particular situation, they did not plead enough facts to fit within that self-defense exception to the employment at will doctrine, and the discharge of Newton was upheld. There was a quote from the case, though, that I think has particular applicability outside of employment law cases. Tom, can you talk about that for a second?
Sure. We've talked to you all in the past about the standard that our court
Go to the
uses.
next slide, Joe. Sorry.
A standard our court uses to look at the allegations in a complaint, and it has to have a short, plain statement. In federal court, they take a harder look at it. It has to be plausible. And our court has never adopted what's called the plausibility standard that's regular in federal court. So that's one of the differences between state and federal court. But Newton repeats a quote that the court we've seen in a number of cases in the last, say, 5 or 6 years, that even though we have a short, plain statement of claim, you have to have enough facts for the court to understand what the facts are, and you have to plead a viable claim under West Virginia law. So we haven't changed the standard, but I think the court reminds us that the complaint still has to make a claim that states a claim under West Virginia law, and we think that's important.
The next case I want to cover is Blanda versus Martin and Seibert. And in this case, it went up on a certified question to the Supreme Court on whether the criminal statute that describes larceny would support a Harless type claim for wrongful discharge. And what had happened, Blanda was working for the law firm of Martin and Seibert, and she believed that there was inappropriate billing going on, and she addressed it internally with some of the accounting people and mentioned it to one of the lawyers, not one of the partners there. And the young lawyer that she talked to suggested that she get in touch with somebody who, an attorney outside, and she ends up getting that lawyer from outside reports it then to the U.S. attorney. And you might remember there was a rating of the firm, but when the case went up, it was clear that Blanda had never reported what was going on outside. She had always reported it internally, and to the extent it ended up being investigated by the U.S. Attorney's Office, it was not because Blanda had reported it herself to somebody outside. Jill, you want to go on to the, so anyway, the Supreme Court said that the question here is whether reporting of suspected larceny by a private employer or to a private employer will support a Harless claim, and the court held it doesn't. If you're going to be talking about Harless type claims, it can't be an internal reporting unless there is a statute that specifically provides for retaliatory discharge action when you report something to a private employer and that employer then fires you. So that if there's a statute in place that prohibits retaliatory discharge, then it would support a Harless type case. I've got 3 other discrimination cases I want to talk about quickly. The McClure management case involved 2 workers in the oil and gas industry who had come up from Tennessee and tried to get hotel rooms where their coworkers were staying. Every time the white coworkers came in, they got hotel rooms, an apartment type hotel. But when they asked for it, they were told you couldn't, they didn't have any apartments available. They had to do the more expensive nightly rooms. The other thing is that the clerk at the desk got into it with some of the time, would make disparaging remarks toward them and called their employer about a late payment of just a couple of days when she never did that with respect to white guests when they made late payments. The jury returned verdicts of $475,000 for each of the 2 men, and the court upheld the verdict, saying that there was enough information, enough statements and remarks by the clerk that defense counsel was claiming that they were merely rude, and the court said, we think there was enough here for it to go to the jury, and the jury returned what I would call fairly substantial verdicts for both men. The next case I want to cover is Burns versus West Virginia Department of Education and the Arts. And ordinarily we don't cover too many public employment cases, but this is a good reminder of the Supreme Court's view of things. And we're lucky to have Justice Walker on the Supreme Court for those of us who are employment lawyers, because she is so well versed in employment law. And she did a tremendous, so this was an individual who was working for the Department of Education and Arts who had asthma. And for a while, when she would be dropped off at work on a back entrance, and people would open the door for her and help her, and her doctor appointments, they were able to accommodate her needs. But at some point, as she was getting close to running out of sick leave and unpaid leave, she asked if she could perform her work from home on the weekends so that she wouldn't have to take unpaid leave. And the department head said, no, we're not going to let you work from home. And Justice Walker walks through accommodation law and gives a wonderful blueprint of the sorts of things you have to look at in accommodation law, and also discusses when telework is or is not appropriate, and said that the employer wasn't required to provide what the employee wanted, but so long as she was still allowed to do her job. And that in that case, the employer had done it. So there was no discrimination, particularly since the way that they were treating Burns was the same as they treated everybody else who was similarly situated, who had used up all their paid leave. And that I think that's an important thing for us. Yes.
It seems like this case could be applied to the COVID situation.
I think so too. Particularly those people who want to work from home because they or a family member may have autoimmune disease, and whether or not it can or cannot be accommodated.
You know, it's an interesting, I can tell you about this particular plaintiff. Part of the asthma, she had asthma, and one of the things she complained about was during the water crisis of 2014, there was a smell in the office. Well, this same plaintiff brought this action. She also filed a workers' compensation claim, which went to the Supreme Court and was denied. And she also sued the water company. And that ended up being part of the class action settlement. But this one plaintiff kept and we think this is good, kept a bunch of us defense lawyers busy for a little bit of time.
Litigious employee. The next case I want to talk about is Hensler versus Turnout. And in this case, One Stop had sold to, I can't remember who it was, which in turn leased to an outfit called Turns Out. And they had an employee, One Stop had an employee by the name of Hensler, who had been a senior management manager for them and had supervised several stores. And as the acquisition took place, One Stop did a severance package working with the buyer on a severance package that was a release of all discrimination claims from Hensler so that he would not claim age discrimination. And of course, they paid him under that severance agreement. When he applies for a job at Turns Out, the lessee of the buyer of the One Stop, he applies for a job and he's denied the job, so he files an age discrimination case against Turns Out. And they filed a motion for summary judgment saying, we were included in that release. And the court did not uphold the motion for summary judgment on the appeal because they said whether or not the release's language extended to Turns Out is something that can still be determined by a jury or the judge. We're going to send it back. And it is significant for businesses because a lot of times we are doing a release of discrimination claims where we're including affiliates, subsidiaries, others. And if you know in particular that you've got a buyer of your business, and that's one of the impetuses for going through the severance agreement process, the only way that would have absolutely saved Turns Out would have been for them to have been listed in the agreement or some other way of identifying them so that they would have been covered by the release and able to get motion for summary judgment.
Good.
Jill, do you want to go ahead and handle the next case?
Yeah, and just to intro, this was my Halloween costume, and what you don't see are pajamas on the bottom. And I assure you today, I am fully dressed in the office. So thanks, Tom, for picking that outfit, for picking that picture. So this case is a condemnation case. So what we all know about condemnation cases is we're talking about government takings of private land. And the real issues in those cases are what is the value of the land and how much money will the government pay you for your private land. This case actually drills down on that a little bit farther and is actually pretty interesting. So the Pfeiffers owned real property in Mineral Wells, Wood County. They own a convenience store, gas station, and I think a wrecker service. And the Department of, they had more than 2 acres, valued at, I think, $2.5 million. And the Department of Highways held some public hearings and announced a project that would essentially take over nearly the entirety of their land. And the announcement was in 1998. And there were a number of delays that affected the Department of Highways projects, changes to the project, not really through any fault. I mean, just public projects that caused the delays in the project to not really take effect of the taking until 2010. So about a 12-year delay. But when you think about someone announcing a public project through your private property, it really immediately affects the value of your land. And that essentially was the argument in this case. And the court calls this condemnation blight. And it's on this slide. And as much as I don't like reading directly from slides, I'm going to. So condemnation blight is the reduction in value that the property targeted for condemnation suffers in anticipation of the taking. Well, that's all logical. If you own a house and you learn that a major interstate is going to go directly near your house, you're thinking, oh crap, not only do I not want to live in my house anymore, nobody's going to buy a house or build a house near my development anymore. So what the issue in this case was, at what point do you start calculating the reduction in value of the property? Is it at the time of the announcement, or is it at the time of the initiation of the project? So there was a long delay here. Was it 1998 or was it 2010? And the court said, no, it's at the time of the announcement. And it doesn't really matter that there was a delay. An unreasonable delay in instituting the condemnation proceeding following its, because some delays relating to public projects are natural and unavoidable, before a landowner may recover damages for condemnation blight, he or she must establish that there has been an unreasonable delay in instituting the condemnation proceeding following its official announcement. So here, the amount of damages owed to the Pfeiffers was at issue. In this case, actually allowed them to recover based on the time, beginning at the time of the announcement. So that's what this case was about. And it's actually pretty interesting. I'm sure it's as thrilling for you all as it was for me.
I'm thrilled.
Would you cover arbitration cases for us?
I'd be glad to. You all probably recall back in 2012, I'm sure you remember this, the Brown versus Genesis case was where the court refused to enforce an arbitration agreement and was pretty summarily reversed by the United States Supreme Court under the Federal Arbitration Act. Since 2012, we've had a series of opinions applying not only the Federal Act, but the West Virginia Arbitration Act, and enforcing arbitration contracts in credit card agreements, in nursing home agreements, and general contracts between business. For this past couple of terms, we have 3 arbitration decisions that are worth your attention, if only briefly. The first is Golden Eagle Resources, where they, in a unanimous decision, enforced an arbitration provision contained in a document that transferred title to mineral interests. In the Bales versus Evans case, it involved a claim against a brokerage house, and it was a widow making a claim that they had fouled up her husband's brokerage account. And the widow said, hey, I didn't sign the agreement, so you can't hold me to arbitration. And the court said, well, wait a minute. You are stepping into place of your late husband, enforcing his contractual and common law rights against his broker, and you can't cherry pick. So you want to enforce the agreement, you're stuck with the arbitration provision. Then in TD Auto Finance versus Reynolds, they refused to enforce an arbitration opinion. And the reason is there were basically 2 pieces of paper. The first was a credit application that had an arbitration agreement in it. Then when credit was approved, they entered into a sales contract, and the sales contract didn't have an arbitration agreement, and it didn't have language in it saying, oh, by the way, the language from the sales agreement or the credit application is merged into this. So the court looked at it and said, hey, wait a minute, separate documents. If you want to have an arbitration agreement, it has to be clearly laid out in the document. And so like, as Anna pointed out in Hensler, if you are doing things with multiple documents, you need to make sure that if you want to arbitrate, which is an interesting decision we could talk about sometime in the lobby bar, but if you want to arbitrate, you got to make sure that it is in fact in the agreement that you want to arbitrate. I want to make a couple more comments about Golden Eagle, simply because that case is a signed opinion by Justice Hutchison. If you could go to the next slide.
Yeah.
And it contains a number of new syllabus points. And so what's significant is that when you transfer mineral rights, even though West Virginia courts by statute have jurisdiction to resolve those disputes, you can, by agreement pursuant to the West Virginia Arbitration Act, agree to arbitrate those claims. And if you go to the next slide, syllabus point 5 is the most significant syllabus point. 3, 4, and 6 are basically directions to the court about how to handle these things. But again, it is consistent with federal and state legislation that dictates that if parties agree to arbitration, courts should enforce it. And so I think all of these decisions, even the decision that didn't enforce the arbitration agreement, are consistent with that direct legislative directive.
Tom, you're on a roll. Take class actions while you're at it.
You know
All
what?
right,
I think
so
I'm going to.
You
I'm
go,
going to
why
steal
don't you do
one
class
from you,
action, and I'm
Tom.
gonna, you be Johnny and I'll be Ed.
Okay, I think that sounds perfect. So first of all, this one's called Municipal Water v. Swope. It should actually be called Municipal Water v. McGraw. And we're going to give our apologies to Judge Swope on this one, because the court was actually reviewing the actions of Judge McGraw when it evaluated this case. So there were 2 issues in this one. First of all, this was a purported class action. Judge McGraw certified a class action relating to the exposure of a putative class, and really a single putative class member who was a customer of municipal water in Wyoming County as a result of potential, illnesses as a result of the water supply in Wyoming County. The issue here was Judge McGraw was actually a potential class member, but he nevertheless reviewed the case and certified the class. So you have 2 issues. On appeal, at some point after the appeal was filed, Judge McGraw really rethought his position, and I'll use air quotes if you can see me, voluntarily withdrew from the case. The court nevertheless addressed that and it issued its ruling saying, yeah, you should have recused yourself. So that's why the case has the style Farrell v. Swope. Is this this? Yeah. Municipal Water v. Swope. Oh, am I doing, this is venue. I jumped ahead to the class action one. Oh yeah. Oh no. Yeah, this is
on class action.
Oh yeah, we're on Swope. So we also have, yeah, McGraw's next. So then we have also a really, the court over the last few years has issued a series of cases that reverse, the series reverses our trial court judges for the failure to conduct vigorous analysis of the Rule 23 factors. So Rule 23 and our rules of civil procedure set forth the standards by which courts can certify class actions. And trial courts appear to not quite be getting the message. And a class cannot be certified unless those factors can be met. And they simply were not met here. And the court said they have to be met. You have to show the detailed analysis in your decisions for satisfying these Rule 23 factors. You have not done that. And as a consequence, this class was not certified correctly, and we are not going to uphold certification here. So there were two issues, one relating to the recusal of Judge McGraw and one relating to the improper certification of the class. And I know that there are a couple of cases that we anticipate the court will rule on. Also, class certification that trial courts have issued. They've certified 2 classes recently. I expect there might be a third in the coming months. So we will see. Tom, chime in.
Yeah, just 2 comments. There is a case that will be issued momentarily called Cernaic, which is going to directly address, hopefully, the criteria, what you need to establish the criteria under West Virginia's most recent and most definitive case, which is State ex rel Gougeot versus West Virginia University Hospital. And I just say that generally, the court is moving towards what the United States Supreme Court has done with Federal Rule 23 in Walmart versus Dukes and Comcast, which is, in very general terms, not only does the class have to pose a common question for all the class members, it has to be capable of posing a common resolution. And what the court has been hung up on in West Virginia is the lack of a detailed analysis of those issues by the circuit courts. And so we'll see. You have Cernaic. I'm involved in State ex rel West Virginia American Water versus Jeffries, or I'm sorry, versus Webster. And the Gougeot case was remanded, and there's been another order issued. So there's a question. I think Jill's thinking of that one maybe going back up. So hope, from the standpoint of business, we hope that the court continues to move towards what the United States Supreme Court has done, because in class action cases, I can tell you, when you research how many of them go to trial, they're not many, because as soon as a class is certified, you have enormous economic pressure to resolve the case, because all of a sudden you're not up against 200 people, you're up against 15,000. So.
And Tom, I'll just reiterate, we want our law to be like the federal law. I mean, it is a good standard for class review and class certification. We are moving that way with our court. We are not quite there. So we'll be monitoring these cases really closely. Okay, now we get to venue. So this is, when I started talking about McGraw, this is what I was thinking of. I confused my own self.
I did this last year.
What's that?
I did the same thing last year. I think in the middle of it, I said, oh, wait a minute.
Yeah. So, and it's because, we get to talk about Judge McGraw again. And we get to talk about how he got reversed again. So Judge McGraw, this is interesting, but it should come as no surprise that there was a contract, and this case involves a dispute between 2 PEOs, professional employer organizations, and I can address it very briefly. Everything that had anything to do with this case, the contract, the parties, the entirety of the business relationship took place in Kanawha County. The plaintiff, nevertheless, though, decided to file suit in Wyoming County. And when venue was challenged, it didn't go anywhere with Judge McGraw. So it was taken up on appeal to the Supreme Court, and the Supreme Court issued a syllabus point that said, where challenge is made to venue, the burden shifts to the plaintiff to establish venue under Rule 12b3. And this was a typical case of venue shopping, and the court said, no, you're not going to do it. Where everything happens in Kanawha County, you need to be in Kanawha County. You can't go venue shopping. So that's really what this case is about. It's pretty simple.
All right, we one of the things that you think about courts is the more you extend the ability to recover for emotional distress, the more you get into really uncharted waters on damages. And common law up until the last, say, 25 years ago, is absent of physical injury, you couldn't recover for pure emotional distress. So the law's changed a little bit, but this case involved an employee working in a mine where there was an explosion, and he sued for the owner of the mine, not his employer, for his emotional distress because he saw another miner get blown up. And the court very, just held that that doesn't state a claim in West Virginia. And this is the syllabus point. You can't recover damages for emotional distress, witnessing an injury to an unrelated coworker. So a very bright line. And the importance of this is it also suggests that when you're talking about these, I witnessed something and I should be able to recover, court's trending towards got to be a close family member, or you have to be right there in the zone, right in the zone of danger with them. So good opinion to kind of cabin in expansion of that area of law.
Okay. This is Mine Temp v. Wells Fargo, and this is an important case for insurance agents and producers in West Virginia. So Mine Temp had a contract to provide miners, its workers, at the Wolf Run mine, an ICG location, and was required to carry CGL insurance of $1 million and to indemnify Wolf Run. Now, Mine Temp obtained it through Chubb, through Wells Fargo, its broker, but the policy excluded coverage for bodily injuries while performing duties related to the insured's business. So after Wolf Run and Mine Temp's contract had expired, one of Mine Temp's employees was fatally injured by a Wolf Run employee. But of course, this would have been excluded under the policy. So the estate sued Wolf Run and Mine Temp asked Chubb to defend Wolf Run, and it declined under the exclusion. So Mine Temp, after the exclusion and the coverage dispute, Mine Temp sued Wells Fargo saying, hey, Wells Fargo, you had a duty to tell me what type of policy and what type of insurance I should have had. So you didn't do your job in being a good agent to me and telling me what I should have had and what I needed to have as proper coverage. So Wells Fargo obviously disputed that. And the court said, so this was essentially a failure to procure insurance. And the West Virginia court said, no, West Virginia does not recognize a duty to advise, and the contract between Wolf Run and Mine Temp had expired before the accident. So this is an important case for insurance agencies and agents.
I will say from an employer standpoint too, it's important because if you are getting insurance and you think you have described the kind of insurance you need, make sure you go through and read the exclusions in your policy, because Mine Temp said they did not understand going through the exclusions. It sounded like they hadn't even read the whole policy, but they didn't realize it had been excluded. And that's something that, had they read it and understood it, could have been dealt with at the front end.
Well, and there's an expectation that people are expected to review their policies and understand them. And there's going to be a higher expectation that sophisticated business people understand the policies that they are entering into.
I'm going to cover the next slide because so many of us that are on this call agree to be on boards of directors of nonprofits. And this involves a nonprofit case. And the facts are so complicated, it would take a while to describe them all. But what is important about this is, as many of you know, some nonprofits don't struggle to find money. They have a revenue generating asset where the money is going into the nonprofit. And that's what was going on here. And one of the members of the board of directors filed a derivative lawsuit against various members of the board of directors. It went up on a certified question about may one director sue another to recover damages on behalf of the nonprofit when that conduct was not ultra vires, that is outside of what their responsibilities or duties would have been. And the court said the West Virginia legislature did not follow the model nonprofit rules, and they specifically did not permit such actions. And I bring it up just so that those of us who are in business and understand derivative lawsuits in corporate law know that you don't have the same opportunities if you're on the board of directors for a nonprofit. Tom?
Let's run through some healthcare decisions. There's 3 or 4 of them I'm going to comment on. The first is Cruz versus Farid, and this is a pretty simple case. Patient was in the hospital. The doctor was treating her, recommended that she stay for another procedure. She said no, signed papers saying, I agree, I'm leaving against medical advice. Later on, had a problem because she didn't remove stents she should have removed, and turned around and sued the doctor. And the doctor said, hey, wait a minute, I told you you need to do this, and you signed this, and you left without medical advice. And so the court essentially found he had no duty to the patient that left without against medical advice, as evidenced by her signature on a form that confirmed that I'm aware that I'm doing this against the advice of my doctors. So that's a good decision for doctors, because you can imagine the plight you're in if you've got to chase people down who write a paper saying they don't want your care. The next case is Solly versus Dameron, and this is a really just worth a mention. Several years ago, we had a case, and the question was, if a pregnant woman is killed in a car accident, can they recover for the wrongful death of her fetus? And the court, and the fetus at that time, it was no evidence that it was unhealthy or anything like that, but the fetus wasn't to the point of viability, and the court said, look, even if it wasn't to the point of viability, we're going to allow that wrongful death action. Fast forward, this plaintiff has an ectopic pregnancy, which by its definition is outside the womb, and the baby will not be born. And the court looked at it and said, using the same analysis, it said, we only allowed these suits for fetuses within the womb. An ectopic pregnancy doesn't come within the definition of person in the Wrongful Death Act. Justice Armstead dissented to the case. So just, these are tragedies and everything, but this is a little bit of a one-off, but we thought it was worth mentioning. The next case is one that gives me some heartburn outside the scope of medical cases or medical professional liability cases. So in MPLA cases, before you sue the doctor, you have to send a notice of claim and certificate of merit. And if you serve that on the doctor before the statute of limitations expires, it extends the statute of limitations. So in other words, you have 30 days after you serve notice of claim to sue the doctor if he doesn't respond and settle the case, or you don't drop it. So if you go on the last day of the statute of limitations and serve the doctor, then you've then extended it 30 days. So everybody understands that. Well, in this case, they not only sued the doctor, this was a prisoner who received care from a doctor while he was incarcerated, he also sued the jail. And so he serves notice on the doctor, sues the doctor in a timely fashion beyond 2 years, and he also sues the jail, and the jail goes, hey, wait a minute, you're beyond 2 years for us. Or, we are not a healthcare provider, we're not subject to the MPLA. And the court said, because he had timely sued one defendant and because he alleged a conspiracy, that the case could proceed and not be dismissed under the statute of limitations at the motion to dismiss stage. So it's a broader, conspiracy is under, as I mentioned earlier, we have a pretty basic pleading standard. And so this, to me, gives me a little heartburn, because if you relate on somebody, you just throw in conspiracy and you at least draw them in for the short term. So I don't think we're crazy about this one. So, and then the last case is, we really don't usually talk about Board of Medicine cases. This case affirmed the board suspending a doctor's license for a year for an improper relationship with a patient. But we wanted to point this out. Anybody who's been involved in litigation, that you got to turn over your emails, your text, your cell phone pictures, And e-discovery has become virtually a cottage industry. So we know that we're spending a lot of money doing that stuff. Then you fast forward to how do you admit it into evidence? And that's an interesting question. And the courts address that by saying, look, text messages, if you receive text messages from an identifiable person, they can be admitted through you. They can be admitted if you can demonstrate enough evidence that it did come from a certain person. So gives us some direction about how to admit those things. And I will tell you that, this is a sword and a shield. If you have employees with stray texts, you have employees with stray emails. I mean, imagine the case Anna talked about where the front desk employee was making derogatory comments to customers, and it cost the company $1 million. So you got to keep track of that. But the same token, we've all had cases where some of the stuff that the plaintiff turns over that they've been texting and they've been emailing and they've been Facebooking is, let's say, not conducive to the claims they're making in court. So this is a valuable and instructive decision for both sides.
Jill, are you covering punitives?
I think Tom is.
We swapped. I can do it. So this is a punitive damages case, and again, you can, if you are a victim of excessive force while you're in jail or by police officers, federal law 42 USC section 1983 lets you bring a cause of action. Okay, and so in this case, the question is, if you bring that cause of action and you get zero in compensatory damages, no lost wages, no medical bills, no out-of-pockets, can you get punitive damages? And in an opinion by Justice Jenkins, they held that you could. A jury may award punitive damages in cases under 42 USC 1983. And you say to yourself, well, that sounds like a horrible opinion, but if you read Justice Jenkins' fairly careful opinion, that is the law. Every court that's, including the U.S. Supreme Court, that's looked at this has recognized it. So it is while we're not crazy about that result, and under other statutes and in state court, that's a questionable result. But under this statute, that's applying the law, a consistent application of the law. And it was interesting, Justice Hutchison dissented to that opinion. So, but worth knowing again, but limited to those circumstances of 42 USC 1983, which is typically against governmental defendants.
I'm handling the next cases, but before I get there, if you've got any questions, please feel free to type them out, or at the end, we should have an opportunity briefly where Brian can let people in if they let him know they want to ask a question. So these next two cases are, you've heard the expression loaves and fishes. These are the pancake and fishes cases. So the first one involves a fellow who comes through, orders pancakes at McDonald's, and every time he comes through and does this, he asks for extra pancake syrup. And finally, the manager says to him, "I'm tired of giving you the extra syrup." And he cusses her, calls her a stupid F and B word. And sometime later, he goes through again and he orders a plain chicken sandwich. And these are his allegations. And what he ends up getting is a chicken patty. And all of us have gone through drive-thrus and not gotten our what we ordered. So when he sees this, he gets to the window and she's there again, the same manager. And this time he cusses her out. And the two of them have words, and she stays relatively professional throughout it. And he gets worse and worse, threatening to come in, and he'll tell her once he gets in there what he is effing able to do. And she calls the police. There's a criminal complaint filed. It gets dismissed at the magistrate court. And when that happens, he sues the manager of McDonald's for defamation and intentional infliction of emotional distress. When the court gets it, it upholds the dismissal based on a qualified immunity, because she was testifying in a criminal case about what had been occurring, and the court said that in doing so, it was not outrageous. Although there can be times conduct would be outrageous, but it's a legal question. And there the court was free to have dismissed the case without it having to go to the jury. The next one is, so that's my pancakes here, my fishes case. This involved a Wayne County magistrate who went fishing with his dad and what appeared to be a friend. There was a limit of 6 trout there at the lake, and there were 2 undercover DNR officers present, not far from them at the time. The magistrate catches his limit, and then he catches 2 more, and he hands one off to his dad and one off to this person he claims later was never his friend. But in any event, the DNR officer sees all this and comes up to the magistrate Ferguson and says, you know, I'm a DNR officer, here's my ID, you know, I'm not lying to you. And Ferguson whips out his Supreme Court ID, slams it on the truck, says, I'm not lying about who I am either. He'd been asked for his ID and his fishing license and his trout stamp, and that was pretty much his response to that. So the officer, who is a corporal, says to his colleague, I want you to go off and, you know, check these other people. And he goes to sit at a picnic table to write out the citation. And the friend leaves, taking 8 trout with him and leaving 5 trout for Ferguson and 5 trout for his dad. And with this, Ferguson gets into a rip snorting fight with the corporal, claiming that he had done nothing wrong and you can't prove I did anything wrong. Well, the DNR files a case with the Judicial Disciplinary Council group. They take it up to a judicial hearing board, and they rule against Ferguson on several of the counts, and they give him a 1-month suspension. It gets appealed by the disciplinary council up at the Supreme Court, and the Supreme Court says he acted in an inappropriate, belligerent, and coercive manner as a judge, and they increase his suspension from a month to 3 months. 2 cases where you get punished for being really outrageous when you're in a disagreement with somebody. Next slide.
Don't do that.
Right, don't do that. So, Tom, would you talk to us about what you think the change in the Supreme Court will bring as a result of the election?
Sure. So we had 3 seats up. Justice Armstead, Justice Hutchison were reelected, and then Justice Wooten was elected to the seat vacated by Justice Workman. And the question is, reading the tea leaves, do you think it changes the court in any significant way? And it's difficult to say. But even if you assume that Justice Wooten would fill the same seat as Justice Workman, who was probably left of center on some issues, but I would argue not all issues. I mean, Justice Workman voted in favor of every tort reform act that ever came before the court. And so, you know, sometimes it's hard to classify people, but if you assume that he steps into the same kind of position as Justice Workman, kind of leaves our court with the same balance. The interesting question to me about Justice Wooten is where is how he'll rule on legislative things, because he was in the legislature for so long as a delegate and then as a state senator, and long experienced. I noted on there he's a law clerk to John A. Field. John A. Field was a federal judge in Charleston, and Tom Haywood and Warren Upton. There's just a line of, in my judgment, very distinguished lawyers that clerk for that judge. So it'll be interesting, at least to us. The 3 of us are kind of Supreme Court nerds, so to see what happens. But I think this, to me, if you want balance in the court, I think, it's like the Force in Star Wars. To me, there's balance in the Force as we move forward past January 1st of 2021 and hopefully past COVID. I don't know if you guys have any other thoughts on that.
I think we want balance, Tom. I think I think he's not going to be much of an ideological switch from Justice Workman, to be honest. And I mean, I think what we want, let me say this, everyone thought that Menace Ketchum would be a plaintiff's friendly judge, but he proved that what he was an intellectual jurist who viewed the rule of law and applied stare decisis and took his role as an independent jurist very seriously. And I don't know that the new Justice Wooten won't do so. We don't know if he'll view that role similarly or whether he will, whether he won't. So, I'd like to think that he will respect the constitutional role of the judiciary as good judges do. And I think what we've seen in some of the cases we've reviewed is that we have justices seated now who are not activist judges. They are not results-oriented jurists. They look at the law, they apply the facts, and that's the role of the judiciary. And as long as I've been involved in the West Virginia Chamber of Commerce, it has been seeking a fair and balanced, reliable judiciary. And that's what we have right now. So I think we can hope that, with this type of intellect taking the seat on the court, that we can hope that he'll serve that role too.
Yeah, I think
we
the
won't
biggest
know,
thing
though.
businesses want is predictability. And I think
Right.
we're at a point where we can deliver with some confidence predictable results.
Yeah, I think there's a real irony here in some of the very conservative judges that serve and are appointed to the United States Supreme Court who are questioning whether they have to follow stare decisis, whether they have to follow long-held cases, and they talk about super precedent and this and that. And so it's just an odd time to be talking about the things, to me, as you guys pointed out, this idea that we follow the law so it's predictable is a cornerstone of what we want in West Virginia. And whether that's going to change on a federal level is to me both curious and ironic.
It is.
I will say thank you. I think it's time for us to say thank you to Justice Workman for her many, many years of service. And we appreciate her and the service she did for us on the Supreme Court. And while I'm thanking people, I also want to thank all of the people who have worked so hard to put together the cases that we covered here in CourtWatch. When you go to the materials, you will see their summaries and analysis of all of the materials. And we can't thank them enough because they're the people who make CourtWatch possible. We get to tell you about what the decisions were, but those are the people who did all of the work and deserve our thanks. And thank you to all of them there. And that's what we have. If there are any questions, Brian, have you gotten any questions from people?
Anna, I am not seeing any right now. So what I would just remind everybody is, again, thank you to everybody who provided CourtWatch summaries to the chamber. You can go right again on our website, again, www.wvchamber.com, and pull up the 2020 edition of CourtWatch. It is a fantastic document, and it's made possible by the hard work of the so many members of the West Virginia Chamber who take time out of their busy schedules to help put this together. So I'm still not seeing any questions. I would just like to thank Jill, Anna, Tom, the three of you. This was really fantastic. We're so sorry Mark wasn't able to join us, but we understand that, when you're lead counsel on a case and you get an order from a judge, you follow the order of the judge. I think everybody understands that. So.
And Mark helped put all the PowerPoints together. And Jill, thank you for stepping in at the last minute. That can be a difficult task when somebody else has prepared it and you're delivering somebody else's remarks. But we thank you because it took somebody who watches the Supreme Court all the time to step in like that. Thank you.
Well, again, just thank everybody. That concludes the 2020 edition of Court Watch. Fingers crossed that in 2021 we will be back in the Chesapeake room of the Greenbrier for the annual meeting and business summit. So